Souza versus the Sheriff of Bristol County.
Okay. Yes, Counsel.
Thank you, Your Honor. Please call Bruce Assad, representing Sheriff Hodson, along with Gary Smith here today. Your Honor, the essence of this case is whether the various county sheriffs have the authority in which to assess fees to prisoners under their control for the purpose of helping to defray the cost and expenses of the services provided, as well as promoting financial responsibility for the inmate to assist them in their transition back into the community.
Mr. Assad, could I just ask you a factual question? The money that's in the inmate account, where does that come from?
That comes from the inmates or individuals who may potentially family members or friends that may donate money to them into their account, Your Honor, but it also comes from them. There are no service fees in terms of there is no ability to earn money at the prison. So this would be themselves or their family members.
So it's money that their families provide for them?
If they would like to, yes.
So suppose they're indigent and they don't have family members helping, and they don't have money in their account.
They lose, Your Honor, they lose no services whatsoever. If you are indigent, you receive all of the basic services, all necessities that would be if there was no program whatsoever. So there is.
So when you're discharged, do you owe the sheriff money?
When you're discharged, Your Honor, there is a tally. It is frozen for a period of 2 years. If you don't go back to the Bristol County House of Correction, if you don't violate someone else's rights, those monies are wiped off the books. Therefore, they are forgiven. Only if, in fact, you come within 2 years back into Bristol County does that tally start again. But once again, Your Honor, you lose no essential services, no necessities at all. All we're talking about is money's not being used for the canteen, for discretionary items, candy, and the like.
And the money that you collect goes to the general fund, or what happens to it?
It goes to the general fund, Your Honor, also for the benefit of inmates as well as for the benefit of the county. And based on what the ramifications are now of the budgetary constraints, it would most likely go to offset the cost of the facility.
But I don't know if you answered the question. You said it goes to all of these places. It goes to all of these places?
Your Honor, the money can be used for inmate services. It can be used also for the general account. It can be used to offset the expenses of the facility.
Okay, so essentially it's money that can be used in the discretion of the
That's correct.
sheriff to pay any expenses of the
That is
facility.
correct, Judge.
Can right now you're charging $5. Could the sheriff decide $10 a day was reasonable?
If a reasonable, yes, he could.
$20 a day?
The simple answer to that, Your Honor, is he could. Also, the simple answer to that is that, like in any situation, can there be an abuse of discretion? The answer is yes. Whether it be any public official that is given some discretionary authority, but a reasonable fee, $5 that we have here, we would submit, Your Honor, is a very reasonable and fair fee, and barely touches any cost of keep for any of the inmates involved.
Would a reasonable fee be as high as the cost to the county of housing that person?
Judge, that would be a determination that would be made by the courts, but in effect, as long as it would not be in excess of that, I would think that a sheriff may assess a fee, a reasonable fee. I don't know if the courts or anyone would find that the actual cost, it could be $35,000 to take care of an individual over a course of a year, an inmate over a year. No one is saying that is the purpose of this particular program. This is to offset just a very small portion. It's actually meant to mimic what happens on the outside, that you have choices. That if you pay for your room and board, you take care of your medical expenses, you pay for your haircuts before you go out on vacation, before you buy that flat screen TV, and it's meant for a transition back into everyday society, not to offset the actual cost.
So you say to your mother or your spouse, send me some money, and then it's supposed to teach me responsibility because my mother's money is getting spent to take care of me?
First of all, Your Honor, on one point, no one has to send any money, and no one would be deprived of any services. That being said, Judge, just as in the outside, if someone else is assisting you in taking care of your room and board or your medical expenses, you have an obligation to them. It does show you and teach a very strong message about choices in the real world. That it's just, well, there are no free lunches, is really the best way to say it, Your Honor.
What do you say to the argument that the plaintiffs here make, which is that while the sheriff historically has a variety of powers, it's been pretty clear that in the Commonwealth since at least the 18th century, and certainly the 19th, that the legislature has played a pretty comprehensive role in regulating the issue of what sheriff fees. I mean, what the sheriffs or the commissioner of correction, for that matter, but let's focus on sheriffs. That is, the issue of fees, starting from, as I say, the 18th century, then you have 1859, and then you move forward. So that would suggest that this idea, I mean, basically the argument is that there isn't some overall, overarching common law authority on the part of the sheriff to implement or to charge fees.
We don't accept the argument of a brother that was adopted by the Superior Court, Your Honor. When you look at a view of the prison system, there are two prison systems. One, which is the Commissioner of Corrections, oversees the state system, and then there's the county system. The commissioner is a creature of statute, fully and totally a creature of statute. Many of the fees that they're talking about come from Chapter 124, actually Section 1, which are the powers of a commissioner. There are only two of those powers, of the 21 subsections, Your Honor, two of those powers that talk about fees or assessments for a county. Both of them, one is medical and one is for haircuts. I'm sorry, medical is just for state. It's just for haircuts, Your Honor, in terms of a fee that would be established. And that's stated in there that it's in consultation with a sheriff. And in fact, the commissioner has not instituted any fee for haircuts for the county, and that the section specifically states that a sheriff can. So, Your Honor, no, we don't accept the fact that there's a longstanding litany of fees that are assessed by the commissioner, and therefore evidencing an intent by the legislature. On the fees that are issued in terms of victim witness assessments and so forth out of inmate accounts, they're mandatory fees. We're talking about a discretionary authority of a sheriff, which is far different than the state legislature saying, look, you may be able to do it have this discretion to do it, but we want you to do it on a mandatory basis. It's very, very different, Your Honor, than what we're talking about in this particular case.
Thank you.
Thank you.
May it please the Court, Your Honor, Gary Smith for Bristol County Sheriff Thomas Hodgson. Point I would like to make to the Court is that the sheriff is, as an office, is a common law office, and it precedes the establishment of the Constitution in the state. The Constitution recognizes the office, but does not create it. So that the powers that the sheriff historically had remained with the sheriff.
You mean so we don't need any statutes at all to govern what the sheriffs do? Because they have all this authority?
In order for the sheriff to carry out his functions, I would say that there does not need to be any statutes. The legislature, in its discretion and in its wisdom, has determined that certain statutes should be enacted that codify either the common law to some extent or various other prescriptions. Or
doesn't it suggest if the legislature has codified a whole variety of provisions about fees, and they certainly haven't codified this one that has some significance?
Well, there are 2 points to that, Your Honor. One, there is no comprehensive statutory scheme for fees for sheriffs. There are some statutes, some sections that relate to either, under Chapter 124, Section 1, the Commissioner of Correction, an office which is purely legislative, and what the powers are of the Commissioner. In that section dealing with the Commissioner, there is some mention of oversight of sheriffs, but that certainly doesn't purport on its face to be a comprehensive regulation of fees on the parts of sheriffs. There are other sections, two specifically, that deal with victim witness assessments. And in those cases, you can see that when the victim witness statute was adopted that the legislature wanted to make it mandatory that the fees be assessed. But that doesn't mean that the sheriff didn't have that discretion to do that beforehand.
Mr. Smith, has the common law, has the sheriff ever imposed fees on the basis of the common law?
What I would suggest, Your Honor, is that historically, and if you go back and look at some of the treatises and you look at the early statutes enacted even under the provincial...
That's what I'm getting at, the early statutes. It seems to me the imposition of fees has always been a matter of statute.
Well, I think that if you look at those early statutes, there's a presumption that the prisoner was responsible for his or her support while in the keep, and that those statutes talk about, well, how do you settle out that account? And when you settle out that account, who's responsible for the deficit? And that's what those statutes focus on. But they presume an existing practice of charging the prisoner for the keep. And if you follow those statutes through today, Chapter 126, Section 29, still to this day talks about the accounts of the master or the keeper.
I honestly don't understand. I saw it in your reply brief. I don't understand what this statute
I
means.
have no idea what
Well,
it
I think it means two things. One, that that under that statutory scheme, the sheriff goes to the county to have his expenses and his revenues settled as an account. And that includes, historically, if you go back and look at the earlier statutes, that includes revenues obtained from the prisoners from their own funds, revenues obtained from the labor of the prisoners, any other source of income on the one side of the ledger, and on the other side, the expenses. And then the question becomes, when there's a deficit, and from looking at the history, there has always been a deficit, who is responsible for the deficit? Historically, family members were responsible for that deficit, and then the town selectmen were responsible. Over time, that changed, and if you look at the current statute, Section 29, it clearly says that after the accounts are settled, you look to the county and not to the Commonwealth.
Well, Mr. Smith, if I accept your interpretation of the statute, that statute, then every other county in the Commonwealth has been disobeying the statute since time immemorial, because they have not been charging the prisoners or their families for their keep.
I don't think the statute requires the sheriff to statute for the keep. What it requires
Well-
the statute to settle his account. And if he hasn't
It talks-
collected, if he has not collected from the prisoners, then it doesn't go into the account.
Mr. Smith, I've got a hypothetical for you. If the sheriff decided that to teach the inmates responsibility, he was going to rent them out to do work for various businesses and get money paid from the businesses to defray their expenses, could he do that under his discretion?
I don't know if there are constitutional prohibitions on forced labor, but certainly if the prisoners wanted to participate in a work program of that nature, and there was payment made, that the sheriff would be entitled to offset the funds against his costs of the keep. And in fact, the early statutes have just such a scheme incorporated in them.
Okay.
The GED fee, what are the expenses which the sheriff seeks to compensate himself for?
Well, first off, in order for the inmate to take the test, they have to attend preparatory courses. So there's a cost attended and included with providing the preparation for the test. Second, there needs to be additional security present in connection with the administration of the test.
Okay, but
And
what do we make of the fact that the legislature seemed to be insistent that there be no fee attached by the Department of Education to that? Do you think they would have allowed you to impose a fee and undo the benefit of that rule?
Well, I'm not sure it undoes the benefit. It doesn't it reduces, or it provides a partial benefit. If the legislature had intended for there to be no costs associated with the GED administration, then it could have said so. But it chose to say only that the Department of Education could not charge a fee, and is silent as to any correctional institution or other costs from other departments or other elected officials. The other point I'd like to make is that the the program does have a rehabilitative intention, and this similar programs have been reviewed by other courts and found legitimate, as having a legitimate
How is
penological.
it rehabilitative to me if my mother has to pay something to the sheriff?
Your mother doesn't have to pay.
Well,
If
if
your
I
mother
don't-
if your mother chooses to pay, then that becomes an obligation. That becomes funds of the inmate, and the inmate then pays.
Well, let me ask you one other question. I wasn't sure. I understand if you're indigent, you've got this 2-year runoff period. But what if you don't have any money in your account, but you're also not indigent?
If you don't have any money in your account, you are considered indigent because you don't.
All right, so even I just don't choose to put any money in my account, I have plenty of money. You can't go after that money. You just go after my
The
account.
program is not designed on its face to do that.
Okay.
Thank you very much.
Thank you,
I will
Counsel.
Rest my brief. Thank you.
May it please the court, my name is James Pageau, and I represent the plaintiffs. I think the issue in this case is whether the fees charged by the sheriff are authorized either by his general powers under Chapter 16 or Section 16 by the common law, or his general powers to create rehabilitation programs under Section 48. And I think the lower court correctly ruled that these fees conflict with the overall statutory scheme created by the legislature that sets out pretty clearly the circumstances under which correctional authorities, including the sheriff, can charge prisoners fees.
Well, what do we make of all of this history going back 300 years?
I think the history is actually very clear, Your Honor, that going back to English times, there was a sense that sheriffs were corrupt, that things ought to be done in the colonies to protect against corruption by the sheriffs, and that the sheriffs therefore should have all of their fees established by statute. And that was done starting in the 17th century. And not only were the specific fees laid out precisely, there was also clauses in the statute saying that any official who charges any fee other than the ones set forth in the statute, or a different fee or a different amount, that person would be subject to fine. And there was a case in 1828 called Bagley in which a jailer, the statute at that time permitted a turnkey fee when you were admitted and when you were discharged. And that jailer decided to take both fees at the beginning. And
So the only fees you're saying that have ever been permissible are
the
fees
ones
that
by statute.
statutes have provided for.
That's correct.
And
And
none
there
others.
was also a general principle, and I think my brother is correct, that prisoners ought to be responsible for their upkeep while incarcerated. And there was also a statutory system that was set up to deal with that, and that changed too over time. And
Till 1904, right?
well, that was repealed in 1904, but it existed early on, as early as I think 1647. The system was the jailer would go to the court and say, this is how much it costs to detain this person, how do we get this money? And the judge would say, well, I think he should pay it himself or his family or the town. And that kind of system evolved throughout history. In 1836, the statute at that time said that the master or the keeper of the jail, and this was when the masters and the keepers, more than the sheriffs, had control. The master and the keeper should twice a year do an audit or an account of the expenses, and they would look at how much money did the prisoner generate through his work, how much money did it cost to maintain him, and then they would figure out, well, what's owed, and the master could then send the prisoner a bill and say, you owe this, and if he didn't pay it...
So that's not a
then he could
statutory,
sue.
so this is a fee, it's not a statutory fee.
Well, it was a statutory mechanism that set forth how it is that prisoners might be made to pay for their for their upkeep. And then that changed too. In the middle of the 19th century, the legislature eliminated the fees for things like diet or turnkey fees, and it was strictly, if you want to recover from the prisoner, you do it by this mechanism. And the statutes evolved so that in the 1830s, it was the sheriff or the keeper who could send the bill to the prisoner. That evolved so that it became only the county commissioners who could send the bill. And then in 1904, that entire system was repealed, and it was repealed because all throughout the 19th century, it was never followed. It was considered much too cumbersome to try to figure out what prisoners owed and to collect the money for them. So in practice, it was either the county or the Commonwealth in some instances that were paying. And in 1839, for example, the Attorney General wrote a report saying, well, even though on paper the Commonwealth's not supposed to pay unless the prisoner can't pay, in practice the prisoners are never paying and the Commonwealth is paying it all, and we don't really like that. And so the response was to get the Commonwealth out of it and put the whole load onto the county.
The county and the prisoners.
Well, and the county could then go to the prisoners, but the county didn't go to the prisoners in practice, so that in 1904, the governor sort of said, and there'd been a lot of criticism of this kind of practice throughout history, don't bother trying to go to the prisoners. We're not doing it anyway, and so we're going to repeal the authority to do it, and that's what they did.
Was that a complete repeal? Because I noticed that I think in the reply brief it was noted that only a portion of the statute was repealed, that which authorized essentially lawsuits against indigents. Am I wrong?
Well, it's more than that, Your Honor. It was a fairly complicated system that was in place, at least on paper, preceding 1904, and the system was that the keeper would present his bill to the county commissioners. They would either approve it or not. Once it was approved, then the commissioners could ask the prisoner to pay, and if the prisoner didn't pay, then his family might be asked to pay, or the town, and only then would it fall on the county. This Section 29, which sits out there still, that wasn't repealed, you know, that's on the books. It's an odd statute on the books.
What does it mean, that language about defendant, debtor?
It's old language that dates way back to earlier times when, in civil cases, people who owed money could be put into jail until they paid, but the creditor was supposed to pay for their upkeep. And there's a language in there about board, because there at one time was a statute saying prisoners can be made to pay board. That was repealed. I've forgotten when exactly, like 1859, I think.
But has a sheriff in Massachusetts ever had a common law right to recover costs or expenses against an inmate
Never,
directly?
Your Honor. It was always in accordance with either the system that we've just been discussing or particular fees like turnkey fees or fees for diet that were established by the legislature. But there was never, independent of a statutory mechanism or provision, there was never any independent common law right or any other kind of right for sheriffs to charge prisoners. And they didn't do it. It wasn't something that happened either. They didn't even utilize the mechanisms that were available to them, but they weren't. And now that the sheriff in his brief started to rely on the Donahue case and the Champy case, and Donahue, this court said that the correctional powers under Section 48 to establish rehabilitation programs are broad enough because this is a program in part designed to teach responsibility that is encompassed by 48. One big problem with that is that Section 48 explicitly requires correctional officials to offer incentive payments. That's the language of the statute, to encourage participation in rehabilitation programs.
Wasn't Donahue really, though, at least as I read it, more about where rather than what?
Well,
In other
that
words-
was the essence of the case, is can the prisoner be allowed to be on a GPS monitoring
Because
system?
that prisoner had to work, he worked. I
He-
mean,
he-
it wasn't that the program was, I mean, it was where could you do this?
Right, and there is a statute, and it wasn't at play in Donahue, but there is a statute that says if a prisoner works in the community, the correctional people can take a portion of his salary
86F.
for a lot of
Yeah.
things. Excuse me?
86F?
86F, correct. And contrary to what one of my brothers said, all these statutes that establish fees aren't all just mandatory fees. For example, 127, I think it's section 16A, amends 86F for the state, and it says, in addition to the types of costs that you can be made to pay for that are listed in 86F, the Commissioner of Correction may, not shall, may add to that list medical expenses. But that amendment only applied to the Commissioner of Correction. So if you look at 86F now, it says that the sheriff can take from work release wages expenses for certain things, but medical is not on that list. So it's a little odd that the sheriff is arguing that he has this broad power to charge fees, including medical fees, when he can't take medical expenses from prisoners on work release, who are the ones who really have the money.
Would you agree, and maybe I'm not getting this quite right, but with respect to the haircuts,
Yes.
there is a new regulation, correct? That seems like the correct, accepting your view that it really, it's the commissioner who can set the fee, but doesn't the new regulation authorize the sheriffs to do that?
Well, it's a little bit tricky, because the statute certainly says it contemplates the possibility of both state and county prisoners paying for haircuts. No question about that. It also says that the commissioner shall establish the rate, not the sheriff, the commissioner. And what the lower court ruled is, well, the only rate set by the commissioner is $1.50, so that the sheriff, who'd been charging $5, can't charge that much. And the sheriff's argument is, well, the commissioner's regulation actually doesn't really say anything about the counties, which is true, which is why we argued below that the sheriff shouldn't be allowed to charge anything. But the lower court interpreted that regulation to...
I thought there isn't a new...
There's no new regulation.
No new one, okay.
There's no new regulation. So we didn't appeal that portion. We're willing to live with the rate that was set by the commissioner at $1.50. The sheriff argued, well, there's something in the statute that says, except as otherwise provided, the fee shall be what the commissioner has said, and our view of that otherwise provided language is that it simply says that even the fee charged or authorized or established by the commissioner may in some circumstances not be charged if, say, the commissioner's regulations say certain kinds of people are exempt. And with respect to the medical care, well, let me just go back a little bit to the Champy case, which I think is significant. And there, this court ruled that even in the absence of an explicit statute that provides for disciplinary restitution, the commissioner is free to impose a disciplinary restitution sanction. And it was a divided court, and it was a case in which we filed an amicus on behalf of the plaintiffs. But the essence of that case was that because the commissioner has a paramount goal of maintaining security, and because the commissioner in that case had submitted an affidavit, and it's sort of inherently obvious that taking away the ability to charge restitution could frustrate the essential paramount goal of maintaining security, and that restitution was an essential tool in that arsenal, the court ruled that the commissioner had that authority. These costs of care fees are not related to institutional security. There's evidence in the record that they endangered security by causing strong arming and other kinds of problems. This sheriff is the only sheriff in this Commonwealth who charges these fees. Other sheriffs don't support them and haven't asked for them. And so I think that the Champy case is very much distinguishable on those grounds. And with respect to the medical care fees, there again, there is a statute that contemplates that certain prisoners in certain circumstances can be made to pay a medical copay. The lower court ruled that that statutory scheme permits the commissioner of correction, but not the county sheriff, to charge a medical copay. And the court analyzed the statute, and for lots of reasons that are in my brief and in the court's decision, concluded that those fees can be charged to state prisoners but not county prisoners, and that as an alternative to copays in the counties, the sheriff, the legislature set up a provision requiring the sheriff to go to private insurers, if they existed, to try to collect medical expenses that way. I see my time is up. Thank you very much.
Thank you, Counsel.